SJC-10397, Commonwealth v. Berry.
Good morning, Mr. Bland.
May it please the Court, Eric Grant for Sheila Berry. Your Honors, this is an appeal from a conviction of murder in first degree, which was based solely on the theory of extreme atrocity or cruelty. The jury in this case rejected the Commonwealth's theory of deliberate premeditation. The conviction was based on the defendant's conduct in striking the victim over the head with a cinder block, which he did at least 9 times on the medical evidence, and which he did in the presence of 3 eyewitnesses. At trial in this case, the defendant testified. She said she didn't commit this act at all. But the principal defense argued to the jury by defense counsel was that she lacked criminal responsibility for the killing, and specifically on the basis that she was unable to control her conduct on the night of the incident.
If I could interrupt you, at trial, I understand it was the prosecutor who asked for the instruction about the relationship between alcohol and lack of criminal responsibility. But the defendant didn't object. Is that right?
There's no objection to that instruction, Your Honor.
Okay. And also no request for a heard instruction. I mean, in other words, a different version of that would.
The heard instruction. No, there was no request for this instruction on the part of defense counsel. We say that the instruction. Frankly, I wasn't planning to argue that issue this morning because that's quite all right. Because there's so much to talk about in the 33-year argument. But the short answer is that if that instruction were to be given at all, it should have been given in an even-handed manner. There should have been told the jury about the factors that would support a finding of lack of criminal, would support the use of intoxication to reach a finding of lack of criminal responsibility, as well as what the jury were told, which is only the factors that would tend to the use of intoxication would tend to negate a finding of criminal responsibility.
It seemed to me that there was also an issue that there is no that instruction, and it's part of the model instruction, so it's like. But in any event, it doesn't include that it is the Commonwealth's burden to prove beyond a reasonable doubt that the defendant knew or should have known that she had a propensity, that alcohol made her crazy. I mean,
I don't believe it appears in that particular portion of the instruction. I didn't argue that in the brief because it's all over the place on both sides of it. The Commonwealth's burden is on both sides of that instruction in criminal responsibility.
I need to settle in my own mind whether or not it was error to have given this instruction because there was no evidence that the defendant had a latent mental illness, and for that reason alone, the instruction should not have been given.
Well, I guess that would be so. There was no evidence that the defendant had a latent mental illness. What she had, according to the unanimous testimony, was bipolar disorder, manic depressive, which is sort of on and off. She goes on and off. There's really nothing latent about that because she has the disorder at all times.
And your psychiatrists were saying, or psychologists were saying, your experts were saying that she had an active mental illness, and by the way, she was also drinking, and the Commonwealth psychiatrist said, well, she had an active mental illness, but this was caused by drinking.
That's pretty much.
And the instructions said you can, consider drinking if it activated a latent mental illness, but if the defendant knew that she was activating a mental illness, then it's gone, it's out.
That's the thrust of the instruction. The use of the word latent, I think, is a historical. It is purely historical out of the cases. That happens to be the word that was used in the previous cases, so it appears in the instruction.
Does that undermine the defense?
I guess it would, in fact, because in this case there was no claim that the defendant had a mental illness that had existed at some prior time and might have been activated by her drinking it on this occasion.
She had the
Claim was
mental illness right
She
then.
had a mental illness and has had it for many years, including 10 years of psychiatric hospitalizations. So I guess that does undermine the
Well, let me ask you. Let us assume that a person has a substantial mental illness, and let us assume that alcohol magnifies the psychotic behavior of a person who may have a psychoaffective, whatever the new DSM-6 is going to call it. Schizoaffective. But let's assume that the evidence would be that this individual had a substantial mental illness, whatever one calls it, and that person would manifest psychotic symptoms when the person took alcohol. Is it your position then that if the person then takes alcohol, that alcohol has caused the person's behavior, and therefore there can be no defense of lack of responsibility?
No, our position is that the evidence permitted a finding that the alcohol activated her mental illness, and that she was thereby rendered unable to control her conduct as a result of the mental illness, not as a result of the drinking itself, but as a result of the mental illness. And once you reach that point, you reach the point of eligible for a finding of lack of criminal responsibility.
Okay, so what is the error that you claim here now, since you've told Justice Spina that the latency issue doesn't really apply in this case, and that's the instruction which you make reference to.
Well,
so what is the proper instruction that a judge should have given for which it is error to have failed to give it?
Well, he should have, if this instruction were to have been given at all, it should have said not just, it should have said first and foremost the point that's made in the cases, which is that intoxication may activate a latent mental illness.
But this instruction should not have been given, period, should it?
I think it could properly have been given on the evidence. The jury could properly have found that the defendant, well, this instruction with the point you make about latent, this instruction should not have been given for that because of that word. But the jury, in our view,
And then in answer to Justice Gantz's question, you would say, what should have been
what
given?
should have been given was, ladies and gentlemen, something to the effect that, ladies and gentlemen, intoxication may activate
May exacerbate?
or exacerbate a mental illness, and if it does, and if it renders a defendant unable to control her conduct as a result, then you may properly find that she lacks criminal responsibility. The best answer to your question, perhaps, is two model instructions that are set out in the addendum of our brief. There are Superior Court instructions, and this is not new territory. There are two model instructions that present both sides of this activation question. The side that says, yes, intoxication may activate a mental disease, and the side that says, but if a defendant knew or should have known that it would activate the mental disease, then she's not eligible for the insanity.
But it also says, but it's up to the Commonwealth to prove that she knew or should have known.
Yes, Your Honor. Absolutely. Once the issue is raised by some evidence of lack of criminal responsibility or intoxication rendering a defendant out of control, it's certainly the Commonwealth's burden to disprove those points. And I didn't mean to minimize.
I have a fact question. According to the Commonwealth's evidence, she only had a couple of beers. Am I right? 1 or 2 beers and some marijuana in the
She had
afternoon.
rum.
No, Your Honor.
The Commonwealth's evidence.
On the Commonwealth's evidence,
Because as far as I could see, the only evidence that came in about her drinking 3 large glasses of rum that may have affected her, that was as the basis for the doctor's opinion.
She
And it wasn't
testified
in
to
for
having,
substantive-
she testified to having drunk rum as well.
But she didn't say
Yes.
how much.
Yeah, she said
The-
1 to 2 glasses, I think.
she says,
But I don't see intoxication coming from this.
well, she testifies, I had 2 glasses of rum on the evening prior to the incident. I could feel its effects. So that's the
Okay, all right, right, I think that's what
There's
I
no
had
question
written
about
down.
that. I mean,
Okay, that's,
in our
yeah.
argument, I have emphasized the testimony that that she had 3 large glasses of rum.
The defendant
within an hour.
testified to 2 small glasses of rum with dinner and could feel its effect, right?
Yes, that's what she
About that.
testified.
Yeah, but that isn't enough to make intoxication. I mean, there's no evidence, and a layperson wouldn't think 2 small glasses of rum are
Well,
enough.
that's not the only evidence.
What's-
That's just the first point.
Okay, what's more?
There are 2 other points, and let me just say that as to the 3 large glasses of rum, I've emphasized that in our brief. The Commonwealth points out that that was only admitted as limited testimony
Right.
as the basis for the expert's opinion. I accept that under the cases, although one might question the fairness of that, since that was, the basis for 2 of the 3 Commonwealths, or
Listen, we're going through all these hearsay problems. I
right,
mean,
but putting that aside, since I can't change the hearsay rule this morning, the first point raising the intoxication question was the defendant's testimony. Two glasses
2
of
small glasses of rum.
2 small glasses on the night of the incident. The second thing is a point that was indeed emphasized by the Commonwealth's experts, the fact that the defendant's history shows a repeated connection between her drinking and her psychiatric, inpatient psychiatric admissions. I mean, right there you have something that says, and the fact that she's found to be in an active manic state at the time, well, not in every case, but in many cases at the time of her inpatient hospital admission. So there's another inference that can be drawn in support of that connection. And the third thing is a piece of testimony from one of the Commonwealth's experts, Dr. Vazil, I believe, who testified specifically to his opinion that this tragedy occurred because the defendant is particularly vulnerable to alcohol. And when he says that, one has to remember, this defendant, the defendant we're talking about, is a person with a history of 10 inpatient psychiatric hospitalizations. So when he says she's particularly vulnerable to alcohol, one could properly infer that that means because of her mental illness. So
Could I,
that's what raises the instruction in our view.
turning, because this is where you want to go, I think, to the 33E, but admittedly, this is a record replete with evidence of mental illness, a long history. You've got 3 of 5 experts testifying that this is a person who could not conform her conduct. But looking at it at a 33E level, the fact that you have 2 experts who testify to the opposite, and it's a jury question, and what do you do with that?
Well, we recognize that this court doesn't sit as a second jury, but that principle, as I understand it, the point of that principle is this court's not going to re-examine issues of credibility. What the court will typically look to as is the objective historical facts of the incident. That's the most important thing. We don't have, as to your point, 2 experts testify that she was criminally responsible. That's
I'm
something.
thinking about, like, Colleran, where you had no expert on the Commonwealth side.
Correct.
Yeah.
I think the short answer to that is that we don't have trial by experts. The expert's testimony should not control this court's review under 33E. And I think finally, what our argument really is that the opinions of those 3 experts were of the opinion that the defendant lacked criminal responsibility. And as to the other 2 experts, their opinion was overcome by the objective historical facts of the case. And that dealt not only with the defendant's history of mental illness and the facts that suggested that her mental illness had a physiological basis, the brain injury, the brain tumor that existed at the time of the incident, but also to the facts concerning her behavior on the night of the incident, before, during, and after the incident.
Mr. Bland, could I ask you this? Looking at, leaving aside whether the instruction was correct in this case, so leaving that aside, if one had taken either one of your instructions, which really make a big difference, forget about latent, but make a big difference if you have a mental illness, which I think is clear in this case, but whether if the defendant knew or had reason to know that the consumption of drugs or alcohol would activate the mental illness in a particular way, then the instruction says you must find that the defendant was criminally responsible. I know you pointed to just a few minutes ago, you pointed to the testimony of the Commonwealth's expert, but could you just tell me again, why is it that she knew that alcohol would exacerbate it, or she did not know? What is the evidence on that?
There isn't any.
Well, first of all, our position is that she did not know, and that
Was there any evidence that she knew or should have known?
well, I think the only real evidence is the repeated connection between her.
But you can have an illness, and the illness itself precludes you from being able to control your behavior or whatever it is. But I mean, those are pretty strong. So let me put it this way: is what caused the conduct that was so outrageous here the fact that she had consumed alcohol that then exacerbated her mental illness? Is it her mental illness? Was there any attempt to separate out those? Because clearly what these instructions are going to is criminal responsibility. So if, for example, you have bipolar, or you've been committed for inpatient treatment, these are very serious mental illnesses, but they can in certain circumstances be controlled. They can be controlled by taking drugs, for example. In many cases, people with those illnesses know that if they drink alcohol or if they ingest drugs, it is going to cause violent behavior. And so, at least according to what you're pointing to, is we say in those circumstances the person is criminally responsible. I mean, is there a clear separation here between what she was like without alcohol, what she was like with alcohol? I mean, how was the case tried in that sense?
Well, I think the only testimony, I believe I say in our brief, the only direct testimony as to what the defendant knew about how alcohol would affect her is her testimony at trial, in which she says, alcohol made me laugh. It made me feel better. That's the only direct testimony.
Not it made me feel.
Felt the effects of it when she drank the 2 glasses of rum.
Well, I mean,
Not that it made me angry, not that it made me feel violent.
made me feel better. That's what the jury hears. That's the only direct evidence as to what she knows about the effect of intoxication on her mental illness.
I haven't done any research on this, but do we have any law that says that if you have an active mental illness and you know that if you drink alcohol it will aggravate it, you will lose an insanity defense?
Yes.
Yes, that
Yes,
we have
we,
law on
that-
that.
yes.
Well, if one does know, the answer would be yes. One would not. Well,
This is
one
an
would
active.
Not,
This is an active mental
Yes.
illness, not a latent mental illness.
Mm-hmm.
I'm not sure of the answer to that because the cases in this, the decisions in this line of cases all repeat that same latent, use that same language, which I believe, which talks about a latent mental illness. I think that's how I would answer your question. If a defendant knew perfectly well that alcohol was going to cause her to lose control as a result of mental illness, then in this jurisdiction, there's no insanity defense. She's not eligible. What the defendant knew in this case, I've told the court what the direct evidence was. There was also evidence of the repeated connection between her use of alcohol and the hospitalizations. And you might say, well, a reasonable person, having gone through all those hospitalizations, would realize the connection there and, and ought to know not to be drinking. But the answer here is the standard is that's a matter that has to be considered from the defendant's point of view, solely from the defendant's point of view, and taking into account her mental illness. So, although a reasonable person, an ordinary person might properly be expected to grasp the connection there, this is a person with a serious mental illness, and there's nothing to show that she necessarily did or should have grasped that connection. So,
I just had one quick factual question. How is it that that it was the defense counsel who called all 5 of the experts? I mean, I haven't read I don't.
frankly, I imagine it was a strategic move. He says to the judge at one point, he seemed to have it in his mind that he had promised the jury an opening statement that he was going to call all of the experts just to show that he doesn't say this, but I assume the point was just to show that he had nothing to hide.
Did he call the Commonwealth experts first?
He called all 5 experts.
Yeah, what was the order in which he called them? Commonwealth experts first?
I do remember the answer to that. The answer is yes, Commonwealth. The first expert was a Commonwealth expert. Actually, I'm not sure. Oh, and then the 3 defense experts, and then perhaps the prosecutor. No, I know the defense counsel called all 5, so he must have called the 5th one last. But if my memory is faulty on this, counsel for the Commonwealth can correct me.
Thank you, Mr.
I
Blank.
see that my time is up. Thank you, Your Honor.
Good morning, Mr. Thompson.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, for that last question, I believe the order in which the witnesses were called was sequential in the order in which they examined the defendant. There was a witness that said that he thought the defendant was criminally responsible, followed by 3 witnesses who thought that he was not criminally responsible, and closing with the final witness who had been most recently engaged by the Commonwealth and was also called by the defense, but was the final witness there. Your Honor, Your Honor, the Commonwealth's case, in its direct case, simply didn't raise any issue about criminal responsibility, so the defendant simply made a strategic
Right.
choice to present everything.
Yeah, no, I mean, it's usually that, as you know, I mean, it's usually that the Commonwealth would have its witness or witnesses in rebuttal, but, yeah.
It suggests it's immaterial in this case, Your Honor. Your Honor, to perhaps correct a misimpression here, the instruction given here said nothing about latent diseases, diseases whatsoever. In fact, there was no issue raised about latent diseases, and I don't think that that's just a historical anomaly in the case law under the Hurd sort of case, or what my brother calls the activation defense. I think it's the cases are quite clear and consistent that it's one of the essential elements of that kind of activation theory, and it never was present in this case. Your Honor,
So the instruction should not have been given.
no, Your Honor, it still remains true that if the jury could find that the only reason that she reached a point of lack of capacity was because she drank alcohol in addition to her mental illness, and they could find that she had reason to know that she would lose her capacity on that ground, then this instruction is still applicable, and I suggest it's appropriate in this case. The general testimony by at least 3 out of the 5 witnesses, well, 4 out of the 5, I believe, was that, 3 and 1 was on the fence, was that she did have the capacity to generally appreciate the wrongfulness of her general conduct or the wrongfulness of what was going on around her.
That's a different question.
No, Your Honor, it goes to whether or not she has the ability to understand things that are happening around her. And she had a long, consistent history of hospitalizations associated with alcohol abuse, Your Honor. That could give the jury a reasonable basis to find that she either knew or should have known
Mr. Thompson,
that there was an association that would go in that direction.
It is a different thing to appreciate the wrongfulness of your conduct in taking a cinder block and horribly hitting somebody until he dies, and appreciating that if you drink, you're going to get violent. I mean, they really are very different things. So the fact that that you have experts saying, you know, she has a capacity to appreciate the wrongfulness of her conduct, I really think that's going to the time of the murder. And then you have to ask, well, if that's so, could she conform her conduct to the requirements of the law? But that's different from understanding before the fact that that there is a real connection between my manic, violent behavior and drinking.
Your Honor, the testimony here was consistent that she had been able to live and go on and take care of business and do a variety of other actions over years of period of time with sporadic hospitalizations in between. There was no issue raised by anyone that she would not have the capacity to appreciate this connection which should be obvious to anyone.
It's not a capacity to appreciate. It's did she know? It's not just could she have known. It's did she know?
No, it's not, Your Honor. The instruction is quite clear that it's either that she knew or had reason to know with her mental capacity. Did she know or have reason to know that alcohol would have this effect?
But wasn't she doing okay that night until some third party punched her in the face several times?
Yes, Your Honor. I agree with Justice Coward.
That's what set her off, isn't it? The fact that she had been herself had been beaten by somebody else earlier that night.
Beaten is perhaps too strong a word, Your Honor, but that she'd been engaged in that fight and was clearly there was some ongoing anger on her part. Certainly, Your Honor, that it started. Her anger started at least earlier at that. Shortly before the killing, earlier with somebody else, and no question about that. Your Honors, in terms of...
But it's one thing to say, to instruct a jury that alcohol, if you take alcohol knowing that it will activate a latent mental illness, and they'll lose their insanity defense. It's one thing to say that. It's another thing to say, it seems to me, if you take alcohol knowing that it will aggravate a mental illness when there is a distinct possibility that the mental illness in and of itself, even operating at the inebriated level, to strip the person of that mental illness is not right.
Your Honor...
to strip the person of that defense is not right.
No one's been stripped of any defense on this instruction here, Your Honor. The point here, the only thing that the instruction precluded is if this defendant consumed alcohol, knowing that if she did so, it would cause her to lose her relevant capacities here, then criminal responsibility wouldn't be there.
But didn't her psychiatrists or her experts say that the alcohol really didn't have anything to do with her state of mind that
Your
night,
Honor,
that it was the mental illness that was driving it? And the instruction deprived her of that.
No, Your Honor, no, it didn't. No. The real point here, and Your Honor is putting in the activization, the triggering, even the combination into this case, and as the Commonwealth has said in its brief, there is no evidence that somehow the mental disease was somehow inactive until the consumption of alcohol took place. There was no activization, there was no triggering, and no evidence to support any such thing.
Doesn't Dr. Vasile testify almost to that, to say that she has a real weakness, or I forget the word he used.
Vulnerability is what he said.
Vulnerability to alcohol, and that really what was causing what happened that night was the fact that she had drunk.
Your Honor, activation or triggering is the key words in the case law on this line. It is not sufficient that there is an exacerbation of a mental illness by alcohol, and I'd cite to the court from this court's decision in Commonwealth versus Shelley at 381 Mass 340, particularly at 350, 351. The idea that this activation theory is not raised simply because there's a combination of a mental disease and alcohol. That's the Whitman case that came out fairly recently here, Your Honor. That's at 453 Mass 331, both at 339, 339, and 349. If you read those cases, it's clear that the testimony in that case was that there was a combination of alcohol and a mental disease, and this court said it did not raise that activation theory. It was not supported by the evidence. Here, there is no such thing as an activation. What matters is that there's a latent, essentially unknown mental disease or defect that is triggered, that only comes into play when alcohol is consumed. That's because all the case law that talks about it has that factual scenario.
Okay, if I can move you back a moment. Let us assume for the moment that somebody is unable to conform her conduct to the law.
Right.
Okay? If that inability to conform her conduct to the law derives from taking too much alcohol, she has no defense of lack of criminal responsibility, correct?
Right.
If that inability to conform her conduct to the law derives from mental illness, she does have that defense.
Right.
Okay. If she has a mental illness and if the alcohol were to trigger, exacerbate, activate that mental illness to make it more violent than it routinely is, does she have a defense of criminal responsibility?
Your Honor, that is essentially the McGrath case, the case that's addressed the instruction that was for a while being given in reliance on the McGrath case. It's addressed in Commonwealth versus Brennan, and that is the situation where there is a sort of a baseline mental illness in which the person is not lacking in criminal responsibility by that baseline mental illness by itself, but then the person consumes alcohol, and with the alcohol consumption, then they reach the point of losing capacity. The characterization of that situation in Brennan, which is at 399 Mass 358, particularly I'm talking about 363 Note 4, they say in that situation the cause of the substantial loss of substantial capacity is the alcohol, and it is not a situation.
So your answer,
appropriate instruction.
your answer is no.
Your
Your
answer
answer
is
to my
no.
question is, so you're saying then that if one has a mental illness and the alcohol exacerbates it, that one has no defense of criminal responsibility, even if one did not have any idea that alcohol would have that effect?
Because then it is not, there must be a direct causal relationship from the between the lack of substantial capacity and the mental disease and defect. And under Brennan, that is not present in that scenario, because the thing that tips it into the loss of substantial capacity is the alcohol and the alcohol alone.
Okay, so
that
then
is very similar to this case, Your Honor.
Okay, so then you're saying the law essentially ignores one's mental illness if alcohol exacerbates it.
No, it's not that it's, well, I mean, it doesn't reach the level of criminal responsibility. It may have other significant aspects in the case.
So you're saying that if alcohol exacerbates a mental illness, you have no defense of criminal responsibility, even if the jury were to find that it was the combination of those two things, the alcohol with the mental illness, which would have created the inability to conform one's
Your
conduct
Honor,
to law.
that's the state of the case law. That's the state of the case law from Brennan and Shelley.
And
This
you don't
instruction,
think
if I may just for a minute talk about this instruction did not preclude any kind of finding of a combination of alcohol and and mental disease, a defect equaling criminal responsibility. There was, in fact, no instruction in this case that said intoxication does not mean a mental disease or defect. There was nothing like that. That was not in this case at all, Your Honor. That kind of preclusion may have been supported by the law, but it wasn't it wasn't in this case, Your Honor.
How can you say it wasn't? I don't get that. How can you say it wasn't in this case? You've got a woman that every psychiatrist says has a mental disease, right?
Right.
You've got two psychiatrists who say, yes, she's got a mental disease, she's bipolar, but really what was going on here and why we think was that her condition is exacerbated by drinking alcohol, and you have to factor that alcohol in, and that means she could appreciate the wrongfulness of her thing, and we think she could have controlled her conduct because it's really drinking alcohol. Isn't that what Dr. Vasile and Dr. Murphy
No,
are
well,
saying?
Dr. Vasili in particular said that, and Dr. Murphy as well, that what they said, the bottom line to the reason they rejected the lack of criminal responsibility is because, in their opinion, she was able to conform her conduct to the requirements of the law. Then they said that her particular anger, her excessive anger, was attributable to alcohol. They did not say that, no one said that a characterization of either a schizoaffective or bipolar was anger. No one said that or aggressive behavior. No one said that at all. If it was attributed to anything in particular, it was attributed solely to the alcohol. It was not.
That's not what Dr. Rogers said.
Dr. Rogers said that in general, because of her ongoing, independent of the alcohol, ongoing mental disease or defect, she in general lacked the capacity to form a conduct to the law. Alcohol didn't play a particular role in
right.
his. So we don't, again, have an activation by alcohol of anything, Your Honor.
So then the key for you then is the latency issue.
Latency and activation, Your Honor. Latency.
But
They go
I guess
together,
my
I
question
agree.
is there any evidence today in mental health that there exists latent mental illness as opposed to mental illness,
We
which
have a
is
situation such as Angeloni, Your Honor, and Angeloni is cited by her brother, and that's a situation where the testimony was that he had a frontal lobe problem that made him susceptible to
seizure.
seizures. Right, Your Honor, and the alcohol made him more susceptible to seizures, so when he drank the alcohol, there was at least the court found it was inferable that he in fact had a seizure, and then directly it was his seizure that caused him to lack the capacity to the necessary capacity, Your Honor. So there you have a situation where there's no indication that he was aware of his mental condition, and it was activated by the consumption of alcohol. In Whitman, again, you have the situation quite different, much more like here, where there was at least a possibility that there was a combination that led to well, I'm not saying that. The trouble, Whitman more than here had testimony that a combination of alcohol and mental disease could do this. And the court here, this court, it's fairly recently rejected, said there was insufficient evidence of an activation theory, so no harm in not giving that instruction, Your Honor.
And turning to one more question, what does it mean for a mentally ill person to should have known something? I mean,
Your Honor, there's all
have-
kinds of degrees of mental illness, all kinds of degrees of capacity, all kinds of degrees of being aware of your surroundings and the significance of your surroundings and ability to analyze it around it. That they would be taking in the idea there of, I mean, what it is perhaps from a slightly different point of view of, in the absence of direct testimony, is it reasonable in this situation to infer that this person knew or had at least the capacity
But
to
there's a
know?
difference between an instruction which says you may, considering all the circumstance, decide whether or not she knew that this would be the result, versus you should determine whether there was reason to know that this would be the result. They're different.
There is a difference, and I guess the difference might turn on whether she deliberately turned a blind eye or deliberately refused to recognize it, and yet had the capacity, well, within her capacity, knew in fact do that. We make those kinds of distinctions in a variety of things, such as third-pronged malice, of whether a person, the degree that they should know and the circumstances known to the defendant, you know. Your Honor, you pointed out in my brother's argument that came up that there was very little evidence of any kind of intoxication. In this case, it's substantive evidence of any kind of intoxication at all. The defendant did say she had two 2 small glasses of rum some hours earlier when she had dinner and they watched a movie with a friend of hers. Nobody testified as to signs of intoxication on her that evening. No one testified about the classic odor of alcohol or anything, unless anger itself could be could be deemed to be intoxication. There was no first-hand evidence of, in fact, intoxication. She was at a liquor store but wasn't there buying alcohol. No one said she was involved in that at that point.
In fact, she acted quite non-intoxicated when I think she said when she took the first, whatever it was she took, she said, "I'll be back to pay for it later."
When
And then-
she took a bottle of beer
Bottle
to
of
throw
beer,
at the
and she said, "I'll be back to pay for it later." And then when she came back and wanted another, and the clerk said no, she just left. She acted rational.
She was asked to leave, and she
and not,
complied
she
and
didn't,
left.
yeah, she didn't act as if she were intoxicated.
Or in a lacking capacity to conform her conduct, Your Honor, which is a point on the 33E. This is not a case where the facts of the actual incident scream out a lack of criminal responsibility, as the prosecution argued to the jury, and as found by Dr. Vasily in particular. The actions her at various points shortly before and indeed after the killing, she demonstrated an ability to control her behavior and focus it on where she wanted to focus it, and conform her behavior to the requirements of the law. And the jury could find that, Your Honor.
Are you aware of any, or, I mean, there may be, are there any reported cases where you have not only evidence of an actual mental illness, bipolar or schizoaffective disorder, but you also have a tumor that its removal seems to have rendered this particular defendant, changed her from being incompetent to stand trial to being competent to stand trial once it was removed? So you have a tumor, and you have a brain injury, and undisputed evidence that all her behavioral problems started after that fall when she was 14 or 15 and suffered the brain injury. I mean, that's an enormous combination of factors weighing on the criminal responsibility, isn't it?
Your Honor, there certainly are cases where there are findings of conceded, established substantial mental diseases or defects that still there are supported findings of criminal responsibility because the mental disease or defects didn't have particular impact on the night of the crime. Here, in terms of certainly her delusional behavior, there is absolutely no connection between her actions on the night of the killing and any of her delusions about bin Laden or about believing that she had written the lyrics to many of the hit songs. Your Honor, while there was the tumor, while there was, at the same time as she got the correction for the tumor, she started taking her meds again, and so it's a little unclear whether her improvement was attributable to one or the other or both. In any event, Dr. Murphy in particular saw her behavior while she had the tumor, while she had the lack of medication, shortly after the time of the killing, and in his opinion.
I just didn't know if you had any other cases where you had some combination of these, but.
I don't know about the physical injury, Your Honor, but certainly for the acknowledged substantial mental disease or defect, there's both Commonwealth versus Reaver and Commonwealth versus Campanoni, Your Honor. On the 33E, Your Honors, the issue was fully presented to the jury, fairly so. They had differing opinions. They could arrive at their own analysis of the facts of the night, and it's a jury system we have, Your Honor. It's time-honored. They deserve a substantial deference, and here they were given a difficult decision, and by all indications, considered it carefully and arrived at their conclusion. I suggest it deserves to be affirmed, Your Honor.
Thank you, Mr. Thompson.